Okay. Let's see.
This case number 20 CV 131, Managed Leasing Corporation, versus Dustin Wayne Johnson and Kimberly Reed Johnson. Yeah, you, Mr. McCluskey. Pardon? Are you Mr. McCluskey?
I am.
Okay, thank you. Wayman McCluskey II, appearing on behalf of the plaintiff, and you are Dustin Wayne Johnson?
Yes.
Okay. Matter before the court is a objections to garnishment filed by Mr. Johnson. The garnishment was filed on June the 15th. The court had previously granted a judgment, called judgment amount of $17,756.88 on March 16th, 2021. Mr. Johnson has filed his objections to that, and matter of second hearing. All right, now, Mr. Johnson, I've read your objections, and under the law, the court is limited to being able to modify a garnishment based on certain statutorily specified grounds. And my understanding is at this point that your objection is that you either you can be terminated because of the garnishment, but also that it would put you in financial bond. Do you have any other basis for objecting to the garnishment?
Just the way that would fall, if it comes out every week, there's like 2.5 weeks out of the month that it'd leave me with not even enough gas to get back and forth to work. We do all our overtime at the end of the month. So I was going to see if I could set up just where I paid it monthly at one time. That way I could maneuver around my other bills and get everything paid up and just send them one lump sum a month, take care of it.
Well, under the law, I don't have any authority to specify how often. There is a statutory limit. Obviously, it's 25% of the net after they go through the calculation. And the employer is the one that's responsible for collecting it and sending it in to the clerk to then distribute to the creditor. But I can't direct. That's not a statutory objection. So the only thing I could suggest you do is if you talk to Mr. McCluskey, perhaps to work out a payment plan that they wouldn't need to regarnish you because they do have to do it periodically. It's just not a one-time thing, and it goes forever. And so you perhaps can work something out. But other than that, I don't have any basis for anything that I'm permitted to do by law. I can't go through and say, okay, here's how much this person is going to pay, and I don't have that discretion. I'm limited to do certain things that I'm allowed to do, like if they're trying to garnish disability benefits or student loans or Social Security, things of those nature. Then I can disregard it, or I can set it aside. But other than that, I'm not permitted to do anything. So, I have to overrule your objection. But again, the best thing to do is to talk to him. Perhaps you can come up with some sort of a solution. Because it does cost them time in order to continue to do this. It also continues to add court costs for every time. And so if you can work out something that they're satisfied with, then maybe they can withdraw the garnishment then or not refile it when it expires. Okay? All right. Anything, Mr. McCluskey? You have anything, Mr. McCluskey? Okay, all right, thank you.
Please rise.
Are you Travis Ray Carter?
Yes, Your Honor.
All right, case number 21 CR 77, State versus Travis Ray Carter. Mr. Carter, you were indicted by the grand jury back on May the 4th of 2021 on a charge of aggravated possession of methamphetamine, alleged that on or about October 27, 2020, this county knowingly obtained, possessed, or used methamphetamine. Violation 2925.11, the higher vice code of 53 felony. If convicted, that carries a possible sentence of between 6 to 12 months incarceration, a fine of up to $2,500, and a possible license suspension of 6 months to 5 years. Now, you're entitled to have an attorney to represent you in this matter. You cannot afford to hire counsel. The court will appoint one for you. I see you have filled out a financial disclosure form. Is everything in this correct?
Yes, Your Honor.
All right, so you're not employed, you've not received any income at this point. You're looking for your mother. Is that right?
Yes.
All right.
Yes, Your Honor.
All right, then court then finds that you are entitled to appoint counsel. Is this the first time you've been in court on this charge?
Yes, it is.
Okay. All right, the court appoints attorney Sarah Barber of Hillsborough, Ohio to represent you. In the absence of counsel, I'll enter a not guilty plea on your behalf. We'll set your first pre-trial for July the 21st at 2:15 p.m. Final pretrial will be August 11 at 2:15 p.m. Trial date will be August 26 at 8 a.m. How long have you been living at your address in Hamersville with your mother?
30 years.
30 years? All right. And you were, looks like you've been sentenced to prison about, what, 2 different times?
No, I only have one prison number. I'm actually on a case right now in Claremont County.
You're on what?
I got a case in Claremont County where I was just now sentenced on July 1st to a halfway house. But I have to clear this up before they'll let me go to the halfway house.
All right, was that River City?
No, I successfully completed CCC after I caught this charge.
Oh, I see.
Now I'm just waiting to go to a halfway house. So I have successfully completed drug treatment since this charge.
Was that, what facility did you go to?
CCC, Community Correctional Center, up in Lebanon.
Lebanon? All right. All right. Well, then I'm gonna release you on your own recognizance, which is your promise to appear, and if you fail to appear, then you could be prosecuted for an additional felony. The deputy there is going to give you a assignment notice to sign that has your dates and your times on it.
Okay.
And if you fail to appear, then you could be prosecuted for an additional felony, and if convicted, sentenced on that, regardless of what happens in this case. You'll be required to pay a deposit of $171 for certain statutorily required fees within 30 days to maintain an arrangement with the clerk to do that. You're going to be under pretrial supervision of the probation department, 117 East Main Street, so you'll report there as soon as you get out of jail. Do you know where that's located, uptown? Come up to the center of town, which is 50 and 62, and you go east about half a block. It's on the south side. It's got a brick front. The address is 117 East Main Street. Report there immediately after court. Then you'll be required to report to them once a week for 4 weeks, and after that, as they determine if you're going to be in a halfway house, they may be able to allow you to do that other than coming in person, but they'll make that decision once they interviewed you. You'll be required to undergo random drug testing, provide phone numbers for home and employer. You've already had substance use treatment, you said, but I have a standard condition that if they determine you should be evaluated, for instance, if you have a 30 test, they'll probably have you be reevaluated for further treatment, and if there's any treatment indicated, you're to enroll in and follow that during pendency of this action. You're going to be under house arrest, which means you have to be either at your residence or at Hamersville or in the halfway house. Do you know where that's going to be located?
Yeah, it's actually in Lebanon. It's Turtle Creek.
Oh, okay. So you're supposed to go there as soon as you're released today?
I'm guessing so. I think they have a warrant out for me in Claremont to be transported back to Claremont to go to Turtle Creek.
So they have a holder on you there? You know? Do you know definitely has a holder on you?
I do not know, Your Honor.
Okay, all right. Well, I'll just put either at a location. You either be at Hamersville at your residence or in the Turtle Creek halfway house.
Okay.
And then you'll be allowed to leave as they permit in the programming there at the halfway house. You can go to any kind of medical appointments, court proceedings, this or any other case, appointments with an attorney, probation officer, this or any other case, any kind of training, schooling, counseling, church services, working if you're working, any kind of community service, any kind of program they have there in Turtle Creek to be able to apply with. Until you go there, though, you'll be under house arrest at your residence, and you can only leave there if you're released to go and not sent to Turtle Creek right away. You are going to be at your mother's house, and you'll have to be under house arrest there unless you meet one of the exceptions that I just went over, and those will be in your bond that you're gonna sign out of the jail. All right, we'll notify your attorney of her appointment. You can also get her phone number and address from the jail there, so you can contact her once you get out and let her know what's going on with you, so she'll be aware. She'll try to get in touch with you as well. You have any questions?
No, sir, I don't.
All right, thank you.
Thank you.
Send you back. Carry the plans, or they call it, or tell them. Yeah, thank you.
See you, Mr. Wilkes. All right, you're Seth Wilkes? Are you Seth
Yes.
Wilkes?
Yes, sir.
All right. I have two cases here involving Mr. Wilkes. First one is 20 CR 261, and then the second is 21 CR 92. In case number 20 CR 261, Mr. Wilkes was under indictment for aggravated possession of methamphetamine and possession of drugs. He had been on bond and failed to appear on March 31st. A case was issued for his arrest, and the court now will reinstate the case to the active docket. Bond will be set in the amount of $10,000 plus your own recognizance and $171 service fee prior to release. Court probation if making bond, if you make bond, and then you'll be expected to comply with the original conditions of your bond entry. Include reporting, house arrest, everything else that was in that order. We will set your, let's see, I think the favorite here was the final pre-trial. Yes, that was the final.
Is mine up?
All right, so we will set your final pre-trial for, July 21st, 1 p.m. Trial date will be August 23rd at 8 a.m. And that takes care of that case. Now, the 21 CR 92, you were indicted by the grand jury for failure to appear in the other case, and that alleges that on or about March 31 in this county, 2021, you failed to appear in case number 20 CR 261 after release under the Higher Revised Code 2937.29 in connection with a felony. So that's a charge of failure to appear, a fourth-degree felony, which carries a possible sentence if convicted of between 6 and 18 months and a fine of $5,000. So in the absence of your counsel, I'll go ahead and enter a not guilty plea for you, and you still are indigent here, so I'll appoint, let's see.
I had J.D. Wagner on this case.
Yeah, okay. Appoint attorney Jacob Wagner to represent you, and as I said, they're not guilty plea on your behalf. And we'll set the pre-trial on that on 7/21, 21 at 1 p.m. And final pre-trial, that'd be actually the first pre-trial. And final pre-trial on August 11 at 1 p.m. and trial date we set the same day as the other case, August 23rd at 8 a.m. And bond in this case will be $5,000 plus your OR and $171 in service fee prior to release. And the other usual conditions that you report if you make bond to probation, and then immediately upon release, and then once a week or 4 weeks after that is determined under the random drug test in the order. Provide phone numbers for home zone employer. If recommended by probation, you'll be evaluated for substance abuse and mental health issues. Any treatments indicated to roll and fall in or incur this action. And also, you'll be under house arrest at your residence, 1142 Wise Road in Lynchburg. You have to be there at all times unless you're working, going to and from work, medical appointments, work proceedings in this or any other case. Appointments with an attorney, probation officer in this or any other case. You may also attend any kind of job training, schooling, GED classes, college classes, etc. You may also attend church services. Other than that, you have to be there at all times. And if you fail to comply, then you can be prosecuted for failure to appear again. And if convicted, sentenced on that charge when acting in this case. Have any questions, Mr. Welch?
So total, what's my volume exactly?
15,000.
So
Plus $171 in each case for your deposit, and then you'll be under pretrial supervision of the probation department.
So 10,000 plus 171 twice.
No, I said that's 15,000. It's 10,000 in your old case and 5,000 in your new case for a total of 15,000.
All right.
All right. Anything?
Thank you.
All right, go ahead. Thanks.
Central Orlando, I have Mr. Wilkes on the way down.
You're waiting. Are you Michael Hornschmar?
Yes, sir.
It is case number 17 CR 224. David Ohio versus Michael Hornschmar. Mr. Hornschmar, you were placed on community control. Under the supervision of, I believe at the time, the APA. And that was on, actually originally on February 7th of 2018. And then there were additional conditions after a violation on 2/12/20, and you were under supervision at that time of probation, Hyde County probation. Now there's been a notification that was filed today that alleges that you have violated those orders, specifically Rule 1, that you pled guilty to aggravated possession of drugs under Section 29.5.11, a third-degree felony out of Clinton County Common Pleas Court. You have a sentencing scheduled on August 12th. Rule 2, you failed to report to probation since July 20 of 2020. Rule 3, that after July 2020, you have not verified your address in the Hyde County Probation Department. Rule 15, that you owe $302 in clerk course and made no payments since July 2020. Rule 20, that you failed to complete aftercare treatment as directed. That was signed by Officer Balser this morning, and looking at what appears to be your signature as well. Did you receive a copy of this morning?
Yes, sir.
All right. You're entitled to have a hearing on this matter, Mr. Hornschmar, in which the state's required to produce evidence that proves for satisfaction that you have failed to comply with the conditions. You have a right to have a reasonable period of time to prepare for the hearing. Usually that's 10 to 14 days. You have a right to subpoena witnesses to appear on your behalf and the state. You have a right to have an attorney to represent you. You can't afford to hire one to be appointed. In the event that it's found that you have failed to comply, I can do one of three things. I can continue your community control under the same conditions previously ordered. I can continue with additional conditions that are appropriate. And of course, judgment, the third most serious is I can revoke your community control and sentence you to prison for between 6 to 12 months and fine you $25. done. Now, I see you have completed a financial disclosure form, so I take it that you are requesting that the court appoint counsel for you,
Yes, sir.
alright? You have no income other than you're just getting Medicaid and food stamps, is that correct?
Yes, sir.
Alright. Alright, the court will appoint attorney Danielle Witt, who represents you. There'll be no bond set. We'll set this matter for a hearing. July 20th at 1 o'clock. You have any questions?
No, sir.
All right, thank you. All right, Silas Pulliam. All right, case number 21CR75, State of Ohio versus Silas Pulliam. You're Silas Pulliam? You need to speak up.
Yes,
All right. And Mr. Bunstein, you're representing Mr. Pulliam?
I am, Your
All
Honor.
right, it's Edward Bunstein II, right?
Correct.
All right. You wish to waive the reading of the indictment?
We would acknowledge receipt of the indictment, waive the reading of the indictment. I contacted the prosecutor, and she's allowing Mr. Pullman to apply for the diversion program. So I don't know whether the court,
You need to go ahead and enter a plea at this point. If not guilty, then go ahead and negotiate that with her. Discuss that then at the first pre-trial or earlier if you file a motion for that.
we would enter not guilty, Your Honor.
All right. Right, we'll set the first pre-trial on this for August the 11th. That's a Wednesday afternoon, at 3 o'clock. If you do negotiate a diversion agreement prior to that, you contact the court and we can set that for hearing. So we'll set it tentatively right now for 3 o'clock. And then we'll set a final pre-trial for September the 1st at 3 o'clock. And then the trial date for September the 23rd at 8 a.m.
Your Honor, could I move that August 11th date? I'm going to be out of state.
Oh, okay, what time will you be out of state?
Pardon me?
What's the period you'll be out?
I'm out 8, 9, 10, 11, and 12.
Okay. August 18th?
Perfect.
Great. Released on your own recognizance, Mr. Pulliam, you'll need to go downstairs to the clerk's office and sign the bond. No R's, oath cognizance, that means that you are going to appear as required. And if you fail to appear, then you could be prosecuted for additional felony. And if convicted, sentenced on that, no matter what happens in this case. Bailiff there will give you an assignment notice to sign, it gives you your dates and times. And again, if you do work out something with the prosecutor before the 18th of August, and your attorney and the prosecutor call for to schedule something, you will be required to pay a deposit for certain statutory required fees of $116, and you'll have 30 days to work out payment with the, clerk to do that. You go downstairs to sign your bond. We have a pretrial supervision of the probation department at 117 East Main Street, and that's just right down the street across from the Flagway station. And you'll be required to report to them once a week, 4 weeks, and after that, as it determines, you'll be right there as soon as we get down here. We go down there, and after you get down at the clerk's office, be required to undergo random drug tests and an order by phone number of the home cell employer. Have no, get pregnant, excuse me, by probation, you be evaluated for substance abuse, mental health issues, and treatments indicated. You enroll in and follow that for dependency of this action. And what's your address, Mr. Pulley?
4848 US Highway 50, Bainbridge.
Right. Is that 50 west or east? Is there a direction on it?
I don't think so.
Okay. All right, US 50, Baker, right? So you'll be there, you'll be required to be there unless you're working, going to and from work, medical appointments, work proceedings, in this or any other case, appointment with your attorney, in this or any other case, or probation officer, in this or any other case, you can go to any kind of job training, schooling, college classes, et cetera. You can also attend church services, other than that, you have to be there all the time. You have to apply, and the court could revoke your OR bond and have you held in custody until have a chance to set a new bond that would ensure your compliance with your pretrial release. Have you been to the sheriff's department to be photographed and fingerprinted?
Yes, sir.
All right, so going to get your signed notes from the bailiff, go downstairs to sign your OR bond, and then report to probation, and then stay in touch with your attorney, and there's something worked out. You'll, as your attorney explained the diversion program, that will require you to go to the prosecutor's office and sign an agreement, pay a diversion fee, and they'll explain it how it works in this county. Your attorney will explain it to you. Anything further, Mr. Muncy?
Thank you, Your Honor.